everyone. Welcome to another special edition podcast where we're diving into the intricacies of the Secure Act, more commonly referred to as Secure 1.0, and its successor, Secure 2.0. I'm Constance Brewster, and today I'm joined by my colleague, Emily Zimmer. We're both partners in the Employee Benefits and Executive Compensation Practice Group here at Troutman Pepper.
Thanks for that introduction, Constance. Secure 1.0, which came into effect in 2021, introduced a significant change for part-time employees. It required plans to allow employees who work at least 500 but less than 1,000 hours in 3 consecutive 12-month periods to make elected deferrals to their 401k plans. These workers are referred to as long-term part-time employees.
And 2024 is a crucial year, and it's the first year that long-term part-time employees can become eligible to participate under Secure 1.0. But the story doesn't end there. Secure 2.0 has further modified these rules, reducing the service requirement for the long-term part-time employees to just 2 consecutive 12-month periods starting January 1, 2025.
That's right, and proposed regulations have been issued which answer many questions about how these rules are applied, such as what 12-month periods count, how different methods for counting service apply to the rules, and the requirements that apply to an employee who becomes eligible solely as a long-term part-time employee. In today's episode, we'll highlight the key features of these new rules under the proposed regulations and discuss the next steps that companies sponsoring 401k plans should be taking now.
So whether you're an employer, an employee, or just someone interested in the world of retirement planning, stay tuned as we unravel the complexities of Secure 2.0. Let's get started.
So as background, tax-qualified 401k plans must satisfy certain minimum age and service eligibility requirements under the Internal Revenue Code. Prior to the Secure Act, a 401k plan was not permitted to require as a condition of participation that an employee complete a period of service extending beyond the later of the attainment of age 21 or 1,000 hours of service during a 12-month termination period. Plans can exclude certain objective classes of employees from participation, but the excluded class cannot be a disguised service-based exclusion that violates the minimum 1,000-hour or age 21 rules. For example, exclusion of part-time employees is a service-based exclusion. To comply with the tax rules, plans that exclude part-time employees must allow them to participate if they meet the 1,000-hour rule.
To expand the population of workers eligible to save for retirement, Secure 1.0 added a new minimum eligibility rule requiring that 401k plans permit employees who work at least 500 hours for each of the 3 prior consecutive 12-month periods to make elective deferrals under such plans, even if they did not have at least 1,000 hours of service in a 12-month period. Then, Secure 2.0 modified this rule by reducing the 3-year look-back period to a 2-year look-back period for plan years that begin on and after January 1, 2025, thus making it easier for an employee to become eligible to participate. Those employees who become eligible to participate in a 401k elective deferral feature by virtue of satisfying these rules are referred to as long-term part-time employees.
A key takeaway is that employers need to be able to administer the Secure 1.0 rules for 2024 and then be ready to shift to the more generous Secure 2.0 rules starting in 2025. Now, with this background, let's walk through some common questions about the long-term part-time employee rules. So, Constance, are any groups of employees not covered by the long-term part-time employee eligibility rules?
Yes, certain employees covered by collective bargaining agreements, and then also employees who are non-resident aliens with no U.S. source income are excluded from these rules.
So, can a 401k plan have more generous eligibility requirements?
Absolutely. These rules are minimum eligibility requirements. Plans can, by design, have more generous eligibility provisions than what the code and regulations require. And in fact, some employers allow all employees to participate in the plan immediately or after a short waiting period without any minimum hours or service requirement. These employers don't have to worry about these new long-term part-time employee eligibility rules.
So, what are the 12-month periods that apply for the long-term part-time employee eligibility?
Well, as discussed, these rules count hours in consecutive 12-month periods. The first 12-month period begins on the employee's hire date, and then the next 12-month period begins on the anniversary of the hire date, unless the plan provides that the period shifts to the first plan year beginning after the employee's hire date. This shift to the plan year can result in some overlap in service. For example, for an employee hired on October 1st of 2023, the first 12-month period runs from October 1st, 23 to September 30th of 24. The next 12-month period for a calendar year plan then runs from January 1st to December 31st of 2024. So the overlap is the time from January 1 to September 30, 2024, which is included in both 12-month periods. So if an employee worked 500 hours in both of these 12-month periods, he must be treated as an eligible long-term part-time employee and given an opportunity to make 401k deferrals in 2025, even though he'd only completed 15 months of employment.
Not all plans use actual hours of service or an hours equivalency to determine eligibility. So, what if a 401k plan uses elapsed time?
Great question. So, under the elapsed time approach, service for eligibility is based on the beginning and end dates of employment without regard to hours worked. And since hours are not counted under elapsed time, the long term part time rules do not apply to plans that use elapsed time. Instead, the plan's regular eligibility rules would apply.
So, can a 401k plan still exclude certain groups of employees not based on service?
Yes, so long as the excluded class is based on a reasonable classification that is not based on age or service. So, for example, a plan can exclude employees working at a particular location. However, if the employee transfers from an excluded location to a location that's not excluded from the plan and had previously met the long term part time employee hours requirement, that employee must be immediately eligible to participate as a long term part time employee. So, in other words, service while in an excluded classification still counts for determining long term part time employee eligibility status if the employee later moves into a non excluded category.
Well, can a 401k plan exclude part time or temporary employees?
Well, these exclusions look more like service based exclusions. The plan would need to include a safety valve feature that allows the employee to participate if either the employee works at least 1,000 hours in an eligibility computation period, or if earlier, the employee qualifies as a long term part time employee by working at least 500 hours, but less than 1,000 hours in the relevant either 2 or 3 consecutive 12-month eligibility computation periods.
Well, with these technical rules, this administrative burden may warrant having more generous eligibility provisions to avoid these long term part time rules. So, once an employee becomes a long term part time employee, when does he enter the plan?
It depends on the plan terms. So, plans must specify the entry date for employees who first meet the plan's eligibility requirements. And that cannot be later than 6 months after meeting the plan's eligibility requirement or the start of the next plan year if earlier. Many 401k plans apply earlier entry dates, for example, 30 days, 60 days after meeting eligibility requirements. And it's important to also note that if a long term part time employee terminates employment and is later rehired, the employee generally must be allowed back into the 401k plan as a long term part time employee immediately. So, generally, once eligible, always eligible. So, Emily, what if a long term part time employee later works 1,000 hours?
So, an employee who becomes eligible solely as a long term part time employee may later meet the plan's regular eligibility requirements, in which case the employee will cease to be treated as a long term part time employee. As we'll discuss in a moment, status as a long term part time employee or a regular employee matters for various purposes, including eligibility for employer contributions and treatment for purposes of qualified plan non discrimination testing. So, for example, suppose a plan requires 1,000 hours of service as its regular eligibility requirement. If an employee has 500 hours of service in 2 consecutive 12-month periods in 2024 and 2025, the employee must be treated as eligible as a long term part time employee beginning in 2026 under the Secure 2.0 requirements. But if that employee then works 1,000 hours in 2026, the employee will become eligible in 2027 under the plan's regular eligibility rules and would no longer be treated as a long-term part-time employee.
So, do long term part time employees receive matching or other employer contributions?
They don't have to. That's because an employee who's eligible to make elected deferrals in a 401k plan solely as a long term part time employee may be excluded from eligibility for employer contributions. This exclusion may apply to non elective employer contributions and matching contributions, as well as safe harbor matching or non elective employer contributions for a safe harbor plan. It's worth noting, however, that excluding long term part time employees from eligibility for employer contributions is a choice. This choice applies only if the employee is eligible to participate in the plan solely by reason of the long term part time employee eligibility rules. Any election to exclude long term part time employees from employer contributions should be reflected in an amendment to the plan document. And the treatment of long term part time employees under a safe harbor plan may also need to be reflected in the applicable safe harbor notice.
So, what about non discrimination testing? Do long term part time employees count for this testing?
Well, the answer to that question is again, they don't have to. The 401k plan can elect to exclude employees who participate in the plan solely by reason of the long term part time employee eligibility rules. And that exclusion can be from various non discrimination testing requirements, such as the ADP ACP tests for non safe harbor 401k plans and the minimum coverage test under Section 410B. Any election to exclude long term part time employees from testing must be reflected in the plan document. In addition, if a long term part time employee is excluded from one of the above tests, they must be excluded from all such non discrimination tests. Long term part time employees are still counted in determining whether the plan is considered top heavy under Section 416, but if the plan otherwise excludes long term part time employees from non discrimination testing, then those employees do not have to actually receive top heavy contributions if the plan ends up being top heavy.
So, we know that long term part time employees must be eligible to make 401k deferrals, but can they make catch up contributions? And what about Roth contributions?
That's up to the plan sponsor. Long term part time employees can be eligible to make catch up contributions or Roth contributions under a 401k plan that generally offers those types of contributions to participants. But if the plan elects to exclude long term part time employees from non discrimination testing, the plan can choose to not offer catch up contributions or Roth contributions to those long term part time employees. So, again, such an exclusion can apply only to employees who participate in the plan solely by reason of the long term part time employee eligibility rules.
Well, do special vesting rules apply for these long term part time employees?
Yes, they do. So, vesting service for long term part time employees may be counted on the 401k plan's usual vesting computation period, typically the plan year. They must provide that 1 year of service for any such year is going to be earned when the long term part time employee has at least 500 hours of service. And that's opposed to the normal 1,000 hours of service requirement that typically applies to employees. However, this special rule only applies to service starting in 2021. So it's important to note that this friendly lower vesting service rule continues to apply even if the employee ceases to be a long term part time employee, such as if the long term part time employee later satisfies the plan's regular eligibility rules and moves to being a regular employee. In that case, vesting service while participating as a regular employee would still be based on the 500 hours requirement, even if other regular employees have to work at least 1,000 hours to receive a year of vesting service. We expect this will likely add significant complexity to 401k plan administration for plans that utilize the hours counting service crediting method for vesting service. And interestingly, vesting service for long term part time employees may not ever actually matter. For example, if a long term part time employee is not eligible for employer contributions and never becomes a regular employee, or if all employer contributions are always 100% vested, such as in a safe harbor 401k plan. But employers with employer contributions that are subject to a vesting schedule will need to work closely with their 401k plan record keeper to make sure the special vesting service rule is properly implemented and tracked.
So, do these rules also apply to 403B plans?
Not yet. For now, the proposed regulations solely address 401k plans, but Secure 2.0 does apply the long term part time employee eligibility rules to 403b plans starting in 2025. We hope the IRS will provide additional guidance before then.
So, when do 401k plans have to be amended to reflect these rules?
That is by the end of 2026. So, this deadline applies to all amendments to reflect these new long term part time employee rules, including any amendments to reflect elective features of the new rules. However, plans must begin operating consistently with the new rules, including any elections made starting this year in 2024.
So, this is a lot of technical rules. What should employers be doing now?
So, employers should be working with their legal and other advisors, along with their 401k plan record keeper, to ensure that their 401k plans are now operationally compliant with the long term part time employee rules reflected in the proposed regulations. The potential impact will depend greatly on each employer's business model, demographics, and workforce dynamics. Some employers may consider adopting more generous eligibility rules or move to an elapsed time service counting method to largely avoid the long term part time employee special rules. Others may need to adapt to those new rules and ensure that service is being properly tracked. Those employers will also need to make decisions permitted by the new rules, such as whether to exclude long term part time employees from non discrimination testing. And finally, employers should monitor to see when final regulations are adopted and see if there are any changes in those final regulations. And of course, be prepared to adopt plan amendments by the end of 2026. So I think this is a perfect point to end our episode. It's clear that these acts have brought significant changes to retirement planning and that there's a lot for employers and employees to consider. Companies sponsoring 401k plans need to take steps now to ensure they're in line with these new requirements.
We hope this discussion has provided you with valuable insights and practical takeaways. We recently published a companion article that delves into these regulations in more detail that we will link in the podcast description. If you have any questions or need further clarification on any of these topics that we discussed today, please do not hesitate to reach out to either of us directly.
And in closing, don't forget that we are hosting our annual webinar in September of this year, where we'll provide a comprehensive look at the future landscape of employee benefits and executive compensation. Thank you for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.